The answer is the typical lawyer answer, which is it depends. Some cases get dismissed with prejudice, meaning once there is a dismissal, the prosecutor cannot refile the charges, and other cases get dismissed without prejudice, meaning if the prosecutor fixes whatever the issue was, they can go ahead and refile the charges against you. I will say, if you go to trial, if you get acquitted at trial, the prosecutors can't refile the charges against you unless the charges are being brought by a different prosecuting agency. Like if you got acquitted in the state and then you go to trial with the feds for the same case. In that situation, that is permitted. Otherwise, the state cannot refile charges against you after you beat them at trial. Dismissals that are done with prejudice generally mean that the case was so messed up, the prosecution ran out of speedy trial time, the prosecutors hid Brady evidence, there's some sort of big problematic issue that results in the case being dismissed with prejudice, meaning one and done, they can't refile the charges. There's also dismissals without prejudice. Typically, this involves some sort of issue in the grand jury that the prosecutor then fixes or has the ability to fix. And so long as the issue gets remedied, the judge generally says, well, you can go ahead and refile the charges if the dismissal was done without prejudice, meaning the prosecutor could bring this up again if they fix whatever the issue was. So whether or not charges could be refiled against you really depends on, was the dismissal with prejudice or without prejudice?